May I have a my lord, kind leave to mention on contempt matters. Lordship was written on sit on single on 18 September. Lordship was passed on rule and contemner is alleged contemner before my lord.
সিঙ্গেল বেঞ্চ এখানে কি করে হবে?
With the leave of the
বুঝাবো সেটা ওকে।
May I be permitted to mention, my lord? My lord, this is a review application of which was filed in the year 2022, but no steps has yet been taken by the applicants.
By the applicants.
I am appearing on behalf of the respondent number 16. Due to this reason, we are unable to mutate our name and do anything with the property.
This bench review?
Yes, my lord, this bench. Last date was 8/8/2025, where direction was given to...
Let it be listed before the appropriate bench.
Wait a moment.
Lordship, with Lordship's permissions, may I permitted to mention one matter? Lordship, on in the year 2023, 25th June 2023, Lordship and Honorable Justice Rai Chattopadhyay was give a favorable order in favor of the appellant. But Lordship, it's a contempt matter, Lordship. It was not, since the bench is not there, then the contempt will be not heard by that bench. So Lordship, kindly allow to form that bench so that the matter can be heard, Lordship. Grateful, Lordship.
Commercial thing. Application item number 1.
For the appellant, my lord, this is that matter, my lord, whereby they have filed a suit in a commercial division, my lord, whereby both the parties agree that it should be.
Your only point was that the court had no power to return the plaint under Order 7, Rule 10.
Yes, that point was taken, and before the trial court also had taken a point that this matter is a commercial dispute. This matter is a commercial dispute, but it was not falling under 2(1)(c). That's why it was transferred. But what has happened in this matter? I have filed. There was a commercial transaction between us. He has availed my services for transport of goods. Thereafter, dispute arose. We have filed a Section 9 before the NCLT. Thereafter, between the parties, settlement agreement was entered into, and that settlement agreement breach was forced by this. For forcing the breach of the settlement agreement, this suit was filed. So the disputes are commercial in nature.
Lordship, if I may just
indicate, they say that the settlement agreement is not specifically mentioned under 2(1)(c). That cannot be done because the dispute is a commercial in nature. Last March 2022 was the settlement agreement.
This point was taken before the learned single judge also.
Yes, I said
Lordship
that.
will just kindly appreciate that under Section 2(c) of the Commercial Codes Act,
2(1)(c).
I stand corrected. Section 2, subsection 1, clause C of the Commercial Codes Act, a dispute emanating out of the breach of a settlement agreement that is not subsumed under those heads.
But a settlement agreement cannot exist in its own.
Your Lordship, my learned friend will just continue. On the last occasion, a query had fallen from your Lordships with respect to a judgment of Honorable Justice Badin Ghosh, your Lordship, 1997, with respect to Order 49 not being made applicable to the Honorable High Court at Calcutta. I'm carrying that judgment, your Lordship. Should it be your Lordship's desire, I'll place it.
I do not stand in the way. I stand corrected that Order 7, Rule 10 will be applicable to the Charter High Court because I have found out, I have researched also that notification is there. But I'm only on this point. 2(1)(c), it doesn't fall, but the settlement agreement cannot exist in its own. The writing has to be taken. In the plaint also, it has been stated about the commercial transaction that has happened between the parties. And the dispute arose, Section 9 filed, in between settlement agreement filed.
What is this Sudarshan Prasad Bagadia's case?
But that was relied by me. In the appeal bench passed an order that the same may be transferred to the non-commercial division.
Lord, that is perhaps, my lord, what my learned friend lord submits today. Order to that. Order to that. The consent order. Original order is under challenge. Memo. Memos. plain text Alex করেছে is Alex করেছে stay application stay তোমাকে পয়েন্টটা নিয়ে কি বলি আমি জানি that is not a scope of appeal. What is your what is the
Thus, you can't urge that this is a commercial dispute because that finding you have not challenged in your grounds of
that
appeal.
is what I was going to.
In fact, you have accepted return of the plaint, ground number 4, in your memo of appeal. So therefore, that we will not allow you
And on
to.
the first
The
occasion
operation
before your
also
lordships, he
has
has
stated in
said
the
that
trial court
Maybe your
operation,
grounds of appeal, look at your own grounds of appeal.
but I have based the same on the order that was available of the division bench. But my lord,
Return dismiss করবি, হ্যাঁ, করবি।
but only one thing would kindly see, the law has to prevail, my lord. Whatever stand has been taken, the law cannot be changed or altered.
Where is the law allowing transfer?
But not the transfer, my lord. That
Then
order,
what?
I have based on the appeal order, my lord.
এসো এসো। This appeal is directed against a judgment and order dated July 25, 2025, passed by a learned judge of this court in CS Com 677/2024, whereby the learned judge directed the plaint to be returned to the plaintiff with liberty to the plaintiff to file the same before the appropriate court. Stop. A prayer was also made before the learned judge for extension of the interim order. Stop. However, the learned judge held that since the plaint was being returned along with the interlocutory application, the interim order could not be extended. Stop. Being aggrieved, the plaintiff has come up before us. Paragraph. We have heard learned counsel for the parties. Paragraph. The plaintiff filed the suit in the commercial division of this court. Stop. The learned judge considered the provisions of the Commercial Courts Act, 2015, and came to a finding that the dispute between the parties was not of a commercial nature. Stop. Accordingly, the learned judge directed return of the plaint. Paragraph. Learned advocate for the appellant, you're not taking the point of Order 7, Rule 10 not being applicable. You're not urging that. No. for the appellant says that the learned judge ought to have transferred the suit to the commercial division, to the non-commercial division, instead of directing return of the plaint. Stop. Paragraph. We do not find any provision in law which would have enabled the learned single judge to direct such transfer. Stop. Section 24 of the Code of Civil Procedure reads as follows, set out করে দিন. Reads as follows, set out করে দিন. Paragraph. The transfer could not have been on a bare reading of section 24, comma, we see that the transfer could not have been no. You will learn?
In a bare reading of section 24, we see that the transfer could not have been
directed under that provision. Stop. Paragraph. Learned advocate for the appellant relied on a decision relied on a decision of a coordinate bench in the case of দেখে নেবেন এই ইমপিউন অর্ডারটাই আছে সুদর্শন প্রসাদ বাগাড়িয়া ভার্সেস সাচ এন্ড সাচ করে নাম্বারটা এপিওটি নাম্বার ফাম্বার সব দিয়ে দেবেন এখান থেকে বুঝতে পেরেছেন এটা in support of his এটা কন্টিনিউ করছে in support of his submission that the learned judge could have and should have directed transfer of the suit from the commercial division to the non-commercial division. Stop. We see that the provisions of section 24 of the Code of Civil Procedure was not noticed, was not placed before the coordinate bench. Stop. Further, comma, the provisions of Order 7, Rule 10 of the Code of Civil Procedure permitting a court to return the plaint in appropriate cases was also not placed before the coordinate bench and therefore not considered in the decision of that bench. Stop. Paragraph. In view of the aforesaid, we find no apparent infirmity in the what is it? Oh, second Order 7 Rule 10 not placed, we sentence Paragraph. In view of the aforesaid, comma, we find no apparent infirmity in the order under appeal. Stop. Consequently, comma, the appeal stands dismissed along with the connected application.
The limitation will not be curtailed, my lord. The return of the plaint, the limitation will not be curtailed.
That he has to urge before the.
That when you present the plaint, section 14. Yes. You will get that benefit.
I will kindly state for me. That much, my lord.
Paragraph. Needless to say, comma, the plaintiff will be at liberty to seek benefit of section 14 of the Limitation Act, 1963, before the learned judge before whom the plaint is represented and it is for the learned judge to decide if such benefit is to be
Deeply obliged.
extended to the plaintiff.
In the last occasion, Lord Justice Ahindam Mukherjee's judgment, there was a reference to a 1997 judgment.
Justice Varin Ghosh.
Yes, my Lord. I
He's
have
not.
that.
He's not.
I have that. If your Lordship, my Lord, wants
No,
to.
not necessarily. He's not arguing that point.
Right.
Yes.
Deeply obliged.
Item number
My lord,
there's a
my lord.
significant development in that arbitration. We have got the
I'm compelled to, my lord, ask for not today, my lord. He is not in court today, my lord. But in the same difficulty, very embarrassed, my lord. He is not there, my lord.
The
Kindly,
thing-
kindly, my lord.
Just saying, no, please understand. Are you aware that the determination has changed with effect from Monday? We have received official communication.
I'm
Mr.
not
Sinha
aware.
knows.
I'm not aware.
This court has changed, but what has changed? But I just.
Well, this court will not be there.
would like to do once again, Mr. Singh. Please
No, no, of
think
course not. In fact, in that way, I would discuss that we'll pray for the matter to be kept as part heard, my
No,
lord.
no.
But if that is not,
Well, we have got notice from the arbitrator.
that's on 14th of November, my lord.
14th.
That's 14th of November, my lord. My
Then
lord, the only, my lord,
we
the
are on
only
the
concern was,
31st of
my lord,
October.
If
Yes.
SLP they succeed, then the entire section 9 will go. All the orders will automatically go. 9 or 17, wherever
no, my
there
lord,
is an order that
my lord, I am entirely in my lord's hands, my lord, lordship's hands, my lord. He is not there, therefore I had to make this prayer. My lord, I was not aware of the change of determination.
Not today.
So then I'll join the prayer for Pathar. But this is, well, we can't just go
End
on.
of November. Entire thing, let it be placed before the arbitrator.
Similar orders are there in many other cases.
My lord, may I only make this request, my lord? No, my lord, the only thing that is bothering us, my lord, is this, my lord. My lord, Section 9 court, my lord, ultimately vacated the interim order. The interim order which the Section 9 court had initially granted ad interim injunction, my lord, was not on basis of the merits of the case, because, my lord, when there was no stay, my client had sold certain shares. The court, in that event, without going into the merits, had passed an order, please don't do anything till we hear it. This order continued till disposal, and the disposal, but the order was vacated. In the appeal again, on the very first day, without going into the merits, my lord said, all right, if there was an order of status quo, please maintain. Till date, my lord, there is no order, not a single order. My learned friend will not dispute that on merits of the case.
Appeal court is on merits.
No, no. Appeal court day one, when the brief was, memo was also not filed. If Mr. Mitra will recall. Yes, yes, my lord. My lord,
Fully on
day one, Justice Shomin Singh's bench court number 12, without memo of
was not
appeal.
filed.
May I remind Mr. Mitra what had happened, my lord?
Rearray of notice of motion.
My lord, that is subsequent order, my lord. Day one, it was mentioned without memo of
What
appeal.
was the date?
My lord,
of the order.
court number 12. Then court said don't do anything till they file a memo of appeal. Then the memo of appeal was filed, and then this order was passed, my lord. Again, my lord, courts heard. Court said very well, this order you had maintained status quo all along. Please don't hold your horses till we hear the appeal. And this is where, my lord, this order was passed. Today, my only concern, my lord, is this. My lord, kindly appreciates this, my lord. If the interim order, my lord, passes and refers the matter to arbitration, my lord, this will create, my lord, an impression that my lord has. My lord, that's the only concern that we have.
Influenced by all the orders.
Please understand, we are only saying since an order is subsisting and a tribunal has been formed, we do not wish to proceed here. The entire matter will be considered by the tribunal, but this will not be treated as if we are directing the tribunal to continue the order. Independently, the tribunal will decide. Nothing will influence the tribunal. We'll make that amply clear.
That's fine, but my lord, the only thing that was, because there was no interim order when Section 9 was allowed, my lord. My lord, I am
March.
My lord, Section 9 was ultimately dismissed. Section 9 application was dismissed by Justice Ravi Kapoor's judgment, which is impugned in this appeal.
That's why we are in appeal.
That was no, and because of the conduct of the appellants here, my lord. That's the only, today, my lord, if my lord refers the matter to arbitration, my lord, this will create an impression that the order has been set
We will
aside.
dispel that impression. Issue.
In view of the
An interim order was passed by a coordinate bench on March 3, 2025. Stop. That order continues till date. Stop. Paragraph. Today we are apprised that on the application made by your application under section 11 made by the appellant herein under section 11 of the Arbitration and Conciliation Act, 1996, a learned judge of this court has appointed an arbitrator
Arbitral tribunal
and appointed and has constituted an arbitral tribunal. Stop. The tribunal has fixed November 14, 2025, as the date for the first sitting. Stop. Paragraph. In view of constitution of the arbitral tribunal, we are not inclined to proceed with this appeal, which is directed against an order vacating an ad interim order. Stop. Let the appeal stand disposed of along with the connected application. Stop. The interim order that is in operation shall continue till the end of November, 2025, or until further order of the arbitral tribunal. Stop. The respondents herein would be at liberty to pray for vacating of the interim order before the arbitral tribunal. Stop. The appellant will be at liberty to pray for continuance of the interim order or for any other order. Stop. Or for any other order, upon notice to the respondents. Stop. The arbitral tribunal, paragraph. The arbitral tribunal shall decide the issue of continuance or otherwise of the interim order independently, in accordance with law, and without being influenced by the fact that such an order was passed.
Uninfluenced by trial court's order. Otherwise, it will be binding.
Without influence by, you will know, by the order of the learned trial judge, and also uninfluenced by the fact that a coordinate bench of this court had passed an interim order in the appeal. Stop. I think that makes it quite clear.
What is sometimes else it is done in other cases, treating this appeal as a section 17 application. That's the past precedent. Sometimes it's happened.
That can be done.
That can be done. That will expedite the hearing also. Yes, the pleadings are complete. That can
paragraph. As agreed by and between the parties, let this appeal
by section 17, their opposition is there.
Be treated by the arbitral tribunal as an application under section 17.
Appeal and connected application.
Let this appeal and the connected application be treated by the arbitral tribunal as the appellant's application under section 17 of the Arbitration and Conciliation Act, 1996. So you have already filed your opposition.
The appeal, the paper book was filed, but the entire set is before, my lord, in the appeal.
Opposition is also there.
In the IAs we had filed.
Opposition is there. So your version is on record.
Yes, yes.
Stop. If the arbitral tribunal deems it necessary, it may call for further pleadings from the parties.
Very well.
ঠিক আছে, লাস্টে গিয়ে ডিসপোজ অফ করো, আগে বলেছিলাম।
Since my lord has let the cat out of the bag, will part of the bench remain? In appeal, not even that.
You will come to know within the next couple of hours, I'm sure.
It's a reassigned matter. I cannot 3 and 4.
My lord, I am led by Mr. Shotru Banerjee, my lord. Due to some difficulty, he could not come to court, my lord. I am seeking for an adjournment.
Hey, yeah.
Yes, my lord. Mr. Shatru Banerjee is appearing. He's leading me in this matter, my
He's
lord.
not in court.
Yes, my lord.
Lordship, I'm being led by Mr. Anirban Rai. Your Lordship will recall this is the
Yes, yes,
Assignment.
incorporation.
Yes, assignment of
Get
arbitration
completed
clause.
Not today, not today, what to do?
Much obliged, my lord.
বুঝতেই হবে। কি অরিজিনাল চাই, তুমি কি করছো? অরিজিনাল চাই, এই অ্যাসাইনমেন্ট
grateful, Lordship.
অ্যাজ রেকর্ড করো তো, রেকর্ড করো একসঙ্গে 3 and 4 একসঙ্গে হচ্ছে। On the request made on behalf of the appellant, comma, let this matter stand urgent for the day.
Grateful, Lordship.
Appeal from orders. Item number 5.
I'm for the appellant.
Firstly, your other side is not here, Mr. Kaur.
My lord, I am there, my lord.
Have
So
you really
virtually
heard it? Have we?
No, not yet.
Then please don't start
Oh.
because you won't finish today.
But is the news confirmed?
We have got it officially.
I see.
Now
my
you.
lord, I was appearing for the response.
Very well. Then we come back on
Not today only.
Monday.
We'll only take up matters which can be disposed of today.
This is a 37 appeal. Therefore,
it'll take
it's
time.
going to take time.
We'll say nothing excepting not today.
My lord, I'm appearing for the respondent. My lord, will kindly grant us leave to appear virtually. Lord, I'm being led by Mr. Arushi. My lord can hear me.
Yes, you have appeared. We have noted your appearance. You may now disappear.
Because it's a not today.
Yes.
Item number 6.
Well, this was, my lord, heard by Lordship. My lord, we have concluded our submissions. My lord, kindly mark it as parted. My lordship has recorded. My lord, this bench, my lord, has Mr. Shonak Mukhopadhyay, my lord, is probably online. My lord, we have concluded our submissions. It's recorded, my lord, in your lordships.
Yes.
Yes,
Lord,
but
kindly see, my lord, your lordship's order of 25th.
no, you have concluded. We remember that, Mr. Sinha. You will be in trouble because we can't promise you when we'll be able to sit.
Lord,
When will this bench be able to assemble? This bench is breaking also. This bench is breaking also. Please understand.
It's a government undertaking, my lord. They know hearing, my lord, will be very onerous on the, my lord.
Problem is, as I said, we can't promise you when we'll assemble. It is Mr. Mukhopadhyay argued on 2 days and concluded. He was very brief, we remember. He has filed written notes also.
My lord.
We remember everything. But please don't, we'll just say not today. Take your chance, Mr. Sinha. It'll create difficulty on both sides, I'm telling you.
Well, I'll wait.
Not today, only not today.
Item number 7 and 8.
7, Your Lordship, I appear for the appellant.
And I appear for 8 appellants, Your Lordship.
This was never heard on merits.
This wasn't heard yet.
This was never heard on merits, not today.
Obliged, Your Lordship.
Lord, will it be your lordship's pleasure to, my lord, fix this appeal, my lord, any day convenient to your lordship, my lord?
Benches.
Oh, benches.
Number 9.
I appear for the respondent. This is that sales
Appellant
tax,
not here,
sales tax matter, my lord.
not today.
Lord, your lordships have heard it on merits, my lord.
No. No, Mr.
My lord,
Do not create difficulty for both sides. Not today.
Number 10 and 11.
Not today, my lord.
Not today.
My lord, this matter once your lordship had.
About 2 years ago.
No.
So can't remember a thing.
No, if you
Not today, not
look at the paper, lordship will remember that.
Not today, Mr. Datta, because this,
No, I am
this
saying
won't
that-
this won't conclude today. So not today.
Mr. Good bench.
Item number 12.
My lord.
Item number 12.
Well, be for the respondent, my lord.
My lord, we are for the appellant. Miss.
And we are led by Mr. Mitra and Mr. Mitra, Mr. Jayantu Kumar Mitra has not come to court. My lord makes it not today.
Not today.
My lord, can a date be fixed? Mr. Mitra already started arguing, my lord. He argued for an hour, my lord, last occasion. Any day, my lord. Next Friday, my lord, or any day.
16th November.
16th November. Great for us. Which is Sunday, my lord.
That's right. That's right. No, we can't fix. Not today.
Then can it be even on Tuesday, my lord? Monday, my lord, I have some difficulty.
This bench will not be there.
Okay, wait. Sorry.
Wait.
Not today.
Milord, if I may just ask, Milord, will the assigned matters also, Milord, will be
No, assigned matters, we have to take them up. We'll have to. We can release the assigned matters.
grateful, Milord.
Number 14.
My lord, item number 14, my lord, we had a joint prayer, my lord, subject to my lord's pleasure. My lord, if it could be adjourned for 3 weeks, my lord.
Yes, yes.
My lord, joint prayer of both parties, my lord.
On Italico. On the joint prayer of the parties, comma, let this matter stand adjourned for 3 weeks.
Grateful, my lord.
Grateful.
Great.
Anyways, my lord, I think today in the second half, the bar is taking a resolution, my lord. I think some very young member has expired. The bar association is.
Who, sorry?
My lord, someone, my lord, from the bar association number 13, probably, my lord, young lawyer has expired. So I believe, my lord, bar association is taking a resolution, my lord, of
I see.
defending, my lord, from court in the second half.
Very well, very well.
I just thought I'll inform you. My lord.
We'll sit and write
Yes, my lord,
unless the list is exhausted before that.
Grateful, my lords.
Number 15. Number 16.
I appear for the respondent. Item 16, I appear for the appellant. This is my appeal, Lordship. Lordship, this is an appeal from decree from an order and judgment dated 10th October 2023, Lordship.
Yes.
Lordship, the facts of the case are this is pertaining to a
You
construction.
can conclude today.
No, Lordship.
You can't conclude today.
Lordship, we have to start today. We have
Then
to start.
start on Monday. Start on Monday.
We'll do so, my lords.
Sorry?
We will do so, my lords. We'll start on Monday then.
Start on Monday.
My lord. Great. It's a very short, my lord, matter. We'll start on Monday, my lord.
All right, not today.
Item 17.
Not today.
Non-commercial. Full mention. Item number 1.
For the plaintiff, I'll be very candid in admitting that we are out of time in filing our opposition to the applications
My lord,
filed by the.
I led by Mr. Surajit Nath Mitra, my lord. Thought pass over, my lord.
I affidavit she's straight for.
Positions are already affirmed, your lord. We just need the court's leave to, I'm sorry, I'm not.
When will you file? Today
Today itself.
itself.
May I, my lord?
You're opposing the prayer for extension of time.
There's a reason, my lord.
If we reject your opposition, we are going to award cost.
Is it, my lord?
If we don't accept your opposition, you're opposing the prayer for extension, then we will award cost against you for wasting court's time.
My lordship, I fail to understand why.
Yes, 20 seconds starts now. Yes.
My lord, this is, my lord, the fifth extension.
Lordship.
My lord, whether they have mentioned it or not, my lord, I'm not sure.
Sixth extension.
Before the division single bench, my lord, they had sought, my lord, extension thrice.
Lordship,
May I complete?
Lordship, may I,
my lord?
Lordship, may I submit then? May I submit then?
No, you may not, because we want to listen to him first.
May I, my lord? 1st of July, my lord, the first order was passed. My lord, they did not file.
Order was passed by the division bench.
By the honorable single bench. They did not file the opposition on the date given. The matter reappeared on a day, my lord, when there was a resolution. Nobody appeared from their side. The honorable single bench gave an extension. On the extended date, my lord, they did not file the opposition. Third extension was given. They did not. In spite of filing, my lord, the opposition from an earlier order, they came up with an appeal before your lordship. Your lordship had, my lord, while my lord entertaining the appeal, had observed, my lord, that the appeal is not maintainable. In fact, my lord, Mr. Ghosh was appearing, said, my lord, that it's an appeal out of frustration. I don't know, my lord, what appeals out of frustration. And
what did we do with that appeal? Cut a long story short.
Lordship, my lord, had given them a time to file the opposition. They did not file the opposition within that period of time also.
It is their appeal you are saying.
Their appeal, yes.
Then
But
how can they file?
In my applications, they're supposed to file the opposition. My applications before the honorable single bench. In their suit.
Here are the appellant or respondent before us?
But they want to file two oppositions in two applications pending before the honorable single bench.
Why should we grant you that time?
Lordship, now may I submit? A hue and cry is being raised by a party who has sought for filing an application to adduce evidence after a gap of 13 years, and now one of their applications is to recall my witness after a gap of 15 years. And I am...
May my lord? Lordship will kindly bear with me for 2 minutes. I will make everything clear.
The kind of...
And more so, my lord, may I intimate one more thing also, my lord. These matter before the honorable single bench. May I complete, please?
I'm not even uttering a word. You please complete.
And the appeals are also disposed of, my lord.
Lordship,
and more so, my lord.
A copy of the appeals court, your lordship's court's order. I could not mention the matter at the appropriate time because the entire Calcutta was underwater and I was one of the victims. That is why I could not mention the matter on 25th.
Are you doing a matter before a single bench?
Yes, Lordship.
This is a single bench.
No, Lordship.
Where's the other copy?
Lordship, this is the last order of the single bench.
This is a division bench. You have handed up only one copy, madam.
The direction was given for filing the...
No, copy chahiye, Josh.
Lordship, I'm so sorry, your lordship. I'm so sorry. I'm so sorry, your lordship.
May I also indicate one more thing, my lord? May I also indicate one more thing, my lord?
My lord, I'll just say one thing and then I'll... my lord, lordships will kindly come to page 3, your lordships.
1 week.
Paragraph 3, your lordships.
Oh, wait.
The time to file the opposition expired on the 24th of September. I came on 25th because on 22nd there was a huge deluge. Me and my advocate on record came on the
orders bill kothay?
My mentioning was disallowed.
May I also indicate one more thing, Malad, with Malad Lordship's permission, Malad. The matter before the Honorable Single Bench appeared yesterday. They did not appear.
My lord, there was a
Resolution did not prevent advocates to appear, please. My lord, an order was passed yesterday also. May I hand over 2 copies, my lord, of that order? My lord, it's a prenomination, my lord. When suits are delayed, it's on the, my lord, the defendants delay the suit. My lord, always that's not the case, my lord. Always that's not the case. How about extension? Extension about extension.
Not asking for extension. File করতে চাইছি।
Give a bit beyond time.
Don't file.
Why
Keep
file
it
beyond
effort.
time? Afam, how
They
how
do not want the extension.
No, of course we want extension. Of course we want extension.
How come they Afam will beyond time?
To cost the 17th November, the learned judge has fixed the matter, single judge.
Yes.
Take the opposition, file your reply, Mr. Mitro.
Lordship.
Matter will be heard on 7-1. You pay cost.
Lordship.
Sorry. Then not granted.
Lordship, may I
Out of list. No, you may submit nothing more. Either you agree to pay cost or no.
Lordship, I bow down before Lordship.
Now.
Lordship will kindly hear me.
Now.
The submission of 5
We
extensions.
are not taking into consideration any submission. We are extending time upon payment of cost. By our order dated September 17, 2025, we had granted liberty to the appellant oblique plaintiff to file his application to file his oppositions to the applications of the defendant oblique respondent pending before the learned single judge within a week. Stop. Paragraph. Today, prayer is made on behalf of the appellant oblique plaintiff for extension of time to file opposition. Stop. Paragraph. Mr. Mitro, learned senior counsel, appearing for the respondent oblique defendant, opposes the prayer, saying that the plaintiff is indulging in dilatory tactics. Stop. On several occasions, extension of time was taken to file opposition. Paragraph. Be that as it may, taking a lenient view of the matter, we permit the plaintiff to file his oppositions to the defendant's pending applications before the learned single judge in course of the day, with copy to learned advocate on record for the defendant. Stop. The defendant will be at liberty to file its replies to the said oppositions within a fortnight from date. Stop. The learned judge has fixed paragraph has fixed the matter
17th
on November 17, 2025, when the matter will be listed before the learned single judge.
The other
Stop.
directions.
No, it cost we permit the to file in course of the day, subject to payment of cost assessed at rupees 10,000 to the you don't want it. State Legal Service Authority. State na High Court ki High Court Legal Service Authority.
High Court.
Within a week from date. Stop.
High Court legal service.
In case such cost is not paid and is not paid, the High Court Legal Service Authority and oblique or the defendant will be at liberty to bring the same to our notice. Stop. In that event, The oppositions that we have permitted the plaintiff to file shall stand expunged from the records.
The other directions in the order of my lord 17th September will continue, my lord.
Acha. Paragraph, the other directions contained in the order dated, in our order dated September 17, 2025 shall remain unaltered.
Lordship, just one submission that if a copy of the order is provided to, otherwise my advocate on record and sake that
Today you will get it. এইটা একটু তাড়াতাড়ি করিয়ে নাও না, তাহলে কষ্টটা দিতে পারবে না। খুব উদ্গ্রীব হয়ে আছে কষ্ট দিতে। আলাদা করে সই করিয়ে নিতে হবে। You will get it today. You pay within a week. We have granted you a week.
Filing of the opposition.
File it. We have allowed you. If you don't pay, it will stand expunged. It will be brought to our notice and it will stand expunged.
Apologies, my lord, for coming late, my lord.
Application item number 2.
My lord, item number 2, kindly make it not today, my lord.
Not today.
My lord, I appear on behalf of the respondent number 14 and 15, my lord. Not today. My lord, let it be taken up on Wednesday if it's possible, my lord.
What?
On Wednesday, my lord.
27th. Why? What is special about 27th?
No, Wednesday, coming Wednesday, my lord.
Oh, coming Wednesday.
Yes, my lord.
Make that prayer on Monday.
Last week.
They are asking for not today. We'll grant them not this week.
My lord, I'm sorry, my lord. I forgot that on Wednesday is a holiday, my lord. I forgot.
Is it a holiday?
Yes, my lord.
We don't mind coming.
Grateful, my lord.
Item number 3 and 4.
Not today. Oh, this is the mediation fail. That one. Dry fruit.
Yes,
Fruit.
yes, yes.
All right, not today.
5.
5 and 6, my lord. My appeal, my lord, so far as mediation, execution sent to mediation is concerned, and the other one is, my lord, their appeal, their application for restoration of the appeal, which was dismissed, my lord.
Oh, Mr. Shakko Sen.
2000 days.
More than 1,000 days delay or something like.
999.
Oh, almost 2,000 days.
That's why I remember.
COVID period, some days will be deducted from the 1999 period, Lordship.
Not today, Mr. Mithro, because you might have heard by now that.
Kindly give me a
mediation. Mediation is that year.
After 6, you want it?
Keep it after 6.
Of November?
No. Yes. They want money, my lord. If the money is, my lord, comes in.
Dekho, we are told that the learned single judge who is hearing the execution case has referred the parties to mediation. Stop. The next date fixed by the mediator is November 6, 2025. Paragraph, let this matter be listed once these matters. না দুটো কি একসঙ্গে হচ্ছে নাকি অর্ডার? না উইথ করা নেই, আলাদা আলাদা আছে।
Does not help.
Let this matter be listed once again on November 10.
But my lord,
State order in.
Today we are on 31st, my lord. So they will give. They were supposed to give their calculations of interest, my lord. They have not done that. Let them give it to us, my lord, at least by Monday, so that we can take steps.
This was whose direction? The mediator.
It's an understanding, my lord. Possibly.
Should we record it?
This for the purpose of.
Very well.
Not necessary. Not.
তোমরা দিয়ে দিও ভাই, লাস্ট দিনে দিও।
এটা তোমার 5 আর 6 সেম অর্ডার হবে, আলাদা অর্ডার 5 আর 6 উইথ করে তো নেই। Who is the learned mediator, if you may ask?
Mr. Subroto
Talukdar. Subroto Talukdar.
Item number 7.
No, it is 5-6 action. Oh, I don't know.
চলো কি সব নট টুডে হবে।
8 and 9.
But my appeal, not today.
Item
Mr. Mitra will only take up matters which can be concluded today. You have not seen the new determination?
item number 10.
Can you make it not today?
Yes, yes.
Item number 11.
For the official liquidator.
Not today. All. Na thakna hai.
Item number 13.
Milord, 12 and 13, Milord, I am for the respondent, Milord. This is a matter, Milord, which was thrice, Milord, dismissed for default and then restored by upon mentioning.
Very
Milord,
well.
then.
Very well. Not today.
14. Item number 15.
Time to budget. Time to budget.
তোমার অ্যাপিল আমি কেন ফাইল করব?
আগস্টের সিরিজ সব দিয়েছিলেন ওটা সব ভুলে যাচ্ছে।
Item 16. Not yet called on.
16.
When this state's appeal, I find that there is a direction on the respondent to prepare the paper books and all.
Have all the papers, not we had provided in the paper, not the memo of appeal, not they have not filed. Not kindly not extend the time for them.
No, my lord, the papers, my lord, we also don't have the papers. The state's appeal, state will have to take care of it.
This must be because somebody had told us that.
Yes,
I know.
I did not have not.
I know, but when we take instruction from the client, my lord, we don't have all the papers. The state should take care of his own appeal.
This is
So what should we say today? Tell us.
The direction is on us to prepare the paper book, I believe.
But I'll tell you, Lordship, Milord, this is that matter, Milord, where Milord, the Supreme Court laid down the law, Milord, that security has to be given. Milord, while all this was being decided, Milord, we were not compelled, Milord, to make the entire payment. So, Milord, the entire awarded amount, Milord, they have been received by them. So, unfortunately, we do not, Milord, this is old matter. I do not have the papers. So, Milord, obviously, they do not want the appeal to be heard. So, Milord, now that day they agreed that we will file the paper book. Milord, we said we will bear the cost. Today, Milord, they say we don't have the papers.
Mr. Sinha, if they say they don't have all the papers, how can we still say that you file it?
Your Lordship, not simply Milord, adjourn it for 3
Yes.
weeks. Milord, I'll see, Milord, if I can.
Yes, yes.
Just not simply adjourn it for 3 weeks.
Lordship, the direction is on us that the respondent shall supply a copy of the paper book to the advocate for the appellant. This, my lord, will kindly. This direction in the order, my lord, the last but one line, the second page.
Yes, we have seen. You want us to recall this order?
No, that portion, my submission that we don't have the papers be recorded, my lord. Otherwise, this direction will remain on us.
Read order dated August 2, 2025, paragraph. Mr. Mitro, learned senior counsel representing the respondent today tells us that as per his instruction, the respondent does not have all relevant papers in its possession. Therefore, the respondent is unable to prepare the paper books as was directed by the order dated August 2, 2025. Paragraph. Mr. Sinha, learned advocate appearing for the appellant, says that the matter may be adjourned for some time, and in the meantime, appropriate steps will be taken. Paragraph.
Let them at least indicate what do they have not. Maybe we'll have something, Milord. At least they must be having something, Milord. Let them indicate. We'll try and collate and come.
Paragraph. The respondent should indicate to the learned advocate on record for the appellant the papers that are not in its custody. Paragraph. This custody. This should be done within a week from date. Paragraph. List this matter before the appropriate bench 3 weeks hence.
We will indicate.
I was anticipating this. Even when anticipating.
We have the copy of the award only.
Yes,
Only the award.
Now that you have the money, of course.
I have the award only.
Item 17. Item 18. Item 19. Item 20. 21,
সোমবার থেকে কি অবস্থা হবে?
22,
22 I am for the respondent, my lord.
23, 24, 25, 26,
But I am for the respondent in item number 26, my lord.
I appear for the appellant.
27, 28,
28, my lord, I appear for the respondent.
My lord. My lord, I am for the appellant due to illness of my senior. I am praying for adjournment for 1 week.
Who is your senior?
Pal Chaudhary. Sudeep Pal Chaudhary.
What has happened to him?
My lord, I don't know. But he is sick.
You don't know.
No. That
Your senior is indisposed. You should know. Very well adjourned. On the request made on behalf of the appellant, let this matter stand adjourned for a week.
But may I make one request? One of the respondent I am appearing for is about 85 years old. But this appeal has been pending, and this is a second restoration application which the appellant has filed. The appeal has been pending for quite some time. And my lord, some money has been deposited by the appellant, which I am entitled to with the court, pursuant to the trial court's order, which my lord, I would seek to withdraw upon furnishing necessary security. But if your lordship could keep the appeal as well as the restoration application on any day when your lordship may take it up, because the matter is appearing way down in the list, may not be taken up in some time. So,
Sir, from Monday, this bench will not be there.
29.
If you are the petitioner in this matter, this was section 37 appeal, my lord.
Not today.
Grateful. Much
One, 32,
I appeal under section 37, my lord, ready for hearing.
And I appear for the respondent.
33,
Your lordship, Mr. Jishnu Shah is appearing for the appellants. He is not in court today. I am praying for not today, your lordship.
We are not granting, not this week.
For the respondent.
34, 35,
The appellant, my lord. But we have, my lord, complete our submissions, my lord. The respondent was, my lord, to read
35.
35, my lord.
Not today.
36,
It's my appeal, my lord. So I'm for the respondent.
Your appeal,
My appeal.
not this month.
37, 38,
Mr. Medora, you wouldn't have completed today. Both sides.
39, 40, 41, 42, 53, 54, 45,
Item 40. My lord, item 45, my lord had referred this to mediation. The mediation is not yet complete, my lord. There's another meeting.
So when should we keep it?
My lord, kindly after 2 weeks.
After 2 weeks. Learned, you are for the appellant?
I'm for the appellant.
Learned advocate for the appellant says that the mediation proceedings are still continuing. So paragraph as requested, comma, let this matter stand adjourned and be listed again after 2 weeks. 45. 45. Ki korbe 45.
Grateful, my lord.
46 to 48,
I think that is that matter. Bank 1
1 lakh of rupees as by way of cost.
1 lakh cost.
And so far as the others are concerned, we have also preferred an appeal saying that Citibank should also be made jointly and severally
They are not here, not today only, Mr. Bose.
Very
49 and 50. Fifty-one.
এটা বললি টেন্ডারটা ওটা নিয়ে গিয়ে একটু প্রিন্ট আউট নিয়ে দেখি।
Fifty-two. 53.
My lord, I'm praying for not today, lordship.
4.
Lordship, 53, not today.
55. 56.
Lordship, in item number 56, I'm for the appellant led by Mr. Saurabh Kumar Mukherjee. His father passed away this morning. So
Whose father?
Mr. Saurabh Kumar Mukherjee.
Oh,
So I'm praying for a fortnight's accommodation.
fortnight. He's for the appellant.
Yes, Lordship.
56.
6.
Bengal Industrial Corporation.
Yes, Lordship.
We are told that learned arguing counsel for the appellant lost his father this morning. Stop. As prayed for on behalf of the appellant, comma, let this matter stand adjourned for a fortnight. Fortnight.
Grateful.
57. 58.
My lord, just one fact, my lord, in item number 52, we are also appearing in National Insurance versus Hanuman Estates, my lord.
52, not today.
Yes, sir.
9.
Please, my lords, I'm appearing for defendant number 3 in the matter.
To appeal from decree, your lordship has not started hearing this matter.
Not today.
60. 61.
Well, this matter has not even started.
Not today. You know why we are saying this.
Yes.
Yeah.
I do not know, but I am guessing.
62. 63. 64. 65.
Not today.
56. 56. 57. 68 and 69. 70. 71. 72. 73. 74. 75. 76. 77. 78.
Lordship, in item number 78, my lord, I appear for the applicant, my lord.
Yes.
Lord, item number 78, my lord, I appear for the applicant, my lord. It is a contempt application, my lord. There was a direction upon the respondent, my lord, to file the affidavit on opposition, my lord. Till date, we have received none.
এটা ফাইলটা আছে? ফাইলও পাবে না। Just adjourn for the day, madam. Just not today.
Obliged.
Next side, non-commercial. Item number 1. Item number 1 is my appeal. Well, I mean the commercial.
Non-commercial.
My lord, I am appearing for the municipality.
We mentioned কেন এসছে ভাই? Assignment দেখাও আমাদের একবার।
My lord, I am appearing for the municipality, my lord.
Priyam Banerjee, that matter. Priyam Banerjee. রিলিজ করে দিই কারণ the appellant is not represented. Appellants are not represented. Paragraph. In view of the change of determination with effect from November 3, 2025, it may not be possible for this bench to take up this matter. It may not be possible. It will be very difficult. It will be very difficult for this bench to take up the matter. Paragraph. Let the matter stand released from our list and be placed before the Honorable, the Chief Justice, bracket acting, bracket close, for appropriate direction. 1 or 2, দুটোই same order.
Yes, my lord, same order.
আমি
Number 3. Four.
My lord, from petitioner, my senior is seriously ill, so I'm praying for not today.
seriously ill. Who is your senior?
Sudeshna Basu Thakur. Sudeshna Basu Thakur.
Very well. What has happened to her?
Suddenly fallen ill this morning.
Fell down. Fell down. You pushed her. You did not push her. Very well. Not today.
Number 5.
My lord, I am appearing on behalf of the petitioner. I am praying for not today.
Not this month.
6.
I appear on behalf of the respondent, Lordship. I was defending the 34 order.
Oh.
7 challenged by my defense clients.
Not today.
Your Lordship will take it.
7.
7, I appear for the appellant, my lord. This is that matter, Mr. Shotru goes for that.
Just not today.
8, 9 and 10.
কোনোদিনই হয়নি এটা।
11.
11.
Your Lordship, I am for the appellants. Your Lordship referred this matter for mediation by an order dated 21st August. The mediation is fixed today at 4:30, Your Lordship.
We left this bench, referred.
Yes, Your Lordship. On 21st August 2025. Thereafter, no steps were.
Lekho, learned advocate for the appellant.
Appellants, Your Lordship. It will be
Tells
kept
us-
in the December monthly list of December, Your Lordship, since we'll have to proceed with the mediation.
We will keep it after 3 weeks.
Great.
Learned advocate for the appellant tells us that today is the date fixed for mediation.
Today at 4:30. Yes, Your Lordship. That's all.
Is the date fixed for mediation? Stop paragraph as requested, comma, let this matter stand adjourned and be listed again 3 weeks hence. Date ta diye diyo bracket.
Grateful, Your Lordship.
Hey.
12.
But I appeal. বল না তুই আরে তুই বল তোর বলার ইচ্ছে তুমি বলো না
We'll reserve judgment today
Lordship,
and we'll deliver
because
judgment.
we have argued and
Yes. Hearing is concluded. Stop. Judgment is reserved.
we're grateful for it. And we had filed the written notes also. Both.
Yes, yes, we have seen.
Lordship, I'm grateful.
Grateful. Happy.
13.
Please, my lords. Item number 13, my lord, we had concluded our submissions. Is that, my lord, section 9 and jurisdiction point. My lords.
Not today, Mr. Bagh.
May I only pray, my lord, if it be kept as part heard. My lord, conclusion, my lord, submissions were concluded. We filed the notes, my lords.
Both parties concluded.
We have concluded, my lord. Both parties concluded.
Hey, দেখি ফাইলটা দাও। Who is for your other side, Mr. Bagh?
Lord, Mr. Prabhat Kumar Srivastav, my lord, he was arguing.
We can mark it part heard, but they are not here.
I'll only pray, my lord,
In
if the
fact,
matter
we had directed the matter to be listed as for orders and then for further hearing. Both parties, হ্যাঁ সেই বলছি হয়তো কি সিবি করতে হবে করতে হবে মানে বেরিয়ে যাবে Both parties had concluded.
we had concluded, my lord.
Then why did we keep it as for further hearing?
My lord, this was that matter, my lord, where we had
The problem is in the absence of your learned friend, we can't mark it as part heard.
I leave it to your lordships. We had filed our notes, my lord. My learned friends had also perhaps filed their notes. This was a point of, my lord, jurisdiction of city civil court, where we had argued, my lord, that section 9 jurisdiction would not really be, my lord, in terms of the cause of action only. It will be, my lord, the seat and venue would be sufficient. That's what we had argued.
Mr. Bagh, if you can catch hold of your learned friend
My lord.
come at 2 o'clock once.
We'll do so.
We'll come back only for your matter.
Very deeply obliged.
In his presence, then we can mark it as heard in part by consent of the parties.
Lordship. I'm very, very deeply obliged. I'll do the.
Yes, so at 2 p.m. 2 p.m.
Deeply obliged.
Anybody from your other side? There are 3 learned advocates appearing.
I'll do so. I'll inform them immediately. Very deeply obliged.
Commercial.
Number 1. Commercial.
But it's my appeal. It's a fresh appeal arising out of an order of injunction of over a restaurant under the count. I've on service. I have served. It's coming from the Rajahat Commercial Court. I have served upon them. Is the biryani shop called D Bapi.
Called?
D Bapi. There is a popular biryani shop named D Bapi at Barakpur. So it's a dispute particularly between the family members, father and son.
What is the defect? অনেকগুলো defect.
Stamp.
নতুন রুলসে বলেছে দেখো এই যে ইন দ্য ম্যাটার অফ এই যে অর্ডার নাম্বার সার্চ এইগুলো লিখতে হবে না, ডাইরেক্ট নাকি কোশ্চেন আসবে এই কোশ্চেনটা
Deficit code.
We'll cure the defects. We'll cure the defects in the
Cure the defect and come back.
Otherwise, I can't move it. In the cost title. Defect is in the cost title.
No. Look at the file. There are 5 defects noted, including deficit court fees.
Kindly can't be leave to cure the defect, and affidavit of service will be kept on record.
Affidavit of service filed in court today. We kept with the records. Stop. In spite of service, nobody appears for the respondent/plaintiff. Paragraph. We see that the stamp reporter has noted 5 defects in this appeal. Stop. Leave is granted to the appellant to cure the defects. Paragraph. List the matter.
Lordship.
No. Whichever bench. When?
7 days. 7 days.
7 days. List the matter. 1 week hence.
Grateful.
Item 2.
Yes, sir.
My lord, I am for the appellant.
Yes.
My lord, the subject matter of challenge is an order passed under section 9. My lord, where a joint development agreement, my lord, for development of a property was held to be illegal because it was, my lord, not registered.
You are respondent in the section 9.
My lord, I was the petitioner. My lord, initially an interim order was passed, restraining them from creating third-party interest. However, my lord, after we served, my lord, the order was vacated on this ground.
Against that you have come up.
Yes, your lordship.
What do you call service of
My lord,
the
we had served, my lord, Mr. Gupta was leading me. My lord, we had also, my lord, partially, my lord, advanced arguments before your lordship.
We can't remember anything. We'll just say not today then.
Very well. We'll come back on Monday.
Give a further notice to your other...
My lord, I shall serve them in the course of the day.
Number 3. Four. 5.
I am appearing on behalf of the petitioner. I am praying for not today.
On the prayer made on behalf of the appellant, let this matter stand adjourned for the day.
Number 3.
My lord, this matter was referred to mediation but the other party has not been appearing. As a final chance to them, the mediation is scheduled for tomorrow at 3 p.m. If my lord could take this matter up any day next week.
You are for?
The respondent, my lord. Respondent.
Respondent.
Yes, my lord.
Likhe now, Abhijit. Learned advocate for the respondent says that tomorrow is fixed as the next date for mediation. Stop. Paragraph as requested, let this matter be listed once again 2 weeks hence.
Grateful, my lord.
Item 8. Nine. 10.
Also referring for the respondent, Lordship. Section, there's section
Not
34.
here, appellant, not here, not today.
11.
I'm praying for the appellant. Your Lordship, I'm praying for not today.
12. 13.
Your Lordship, actually, the matter from 11 to 15 is connected matters. Your Lordship,
Very well, all not today.
much obliged, Your Lordship.
16.
I appear for the appellant. उसमें kindly keeps it.
Not today, not today.
Grateful.
15.
Please, my lords. I'm appearing for the my lord petitioner in the matter. My lords. It was heard extensively. I leave it to your lordships, my lord. This is Mr. Shatru Banerjee was arguing against my lord.
Not today.
My lord, deeply obliged. My lords.
19.
For 19, I appear for the appellant.
Appellant.
Appellant, my lord. Appeal from decree, my lord. We lost in the trial.
NTD.
Yes. Grateful, my lord.
21.
Sure. Your learned friend was suggesting that
But
we.
I apologize. There's a new development which we have just come
We
to
just
learn.
now came to know both of them.
Both of us, that the suit has been withdrawn for non-prosecution, so
By
the
the-
appeal becomes infructuous. There's nothing that remains.
My lord,
I'm
we are
handing
not
over the
aware of
copies.
that.
We didn't know
It
this.
was your suit.
No, Mr.
Your suit.
Our suit. No, it's your suit. Your
No,
it's
no.
Section 9 by us.
Section 9 by you, not by me. My lord can deliver
Suit means section 9.
Section 9.
Section 9.
Your section 9.
Our section 9.
Yes.
You have withdrawn it.
We withdrawn.
Hey, likh it down.
It was an interesting point my lord has to deliver the charge.
Sometime later. This appeal is directed against an order passed on an application under Section 9 of the Arbitration and Conciliation Act, 1996, by the respondent herein. Stop. Paragraph. Today we are told that the respondent has. Today we are handed up a copy of an order dated September 10, 2025, passed by the Learned Trial Court, whereby the Section 9 application, being miss case number 2015 of 2024, was dismissed for non-prosecution. Stop. Paragraph. In that view of the matter, this appeal becomes infructuous and is accordingly disposed of along with the. Is there a connected application?
No. It is a connected application.
Along with the connected application.
Very deeply. Very deeply.
Ashbu, Adaite benchte Ashbu.
Before Lordship rises, may I mention, I'm on notice. May I mention item number 7 in Lordship's today's appellate side commercial division matter. But I have given notice to my other side, Lord. The
Yes.
matter has been Lord, already heard by your Lordship. Only we are to give reply. Mr. Bachawat and Mr. Mukherjee, Lord Senior advocates, they have made their substantial arguments on IPRS matters, Lord. We are only praying for that if it can be marked part hard, Lord. On the consent, Lord. I have taken their consent, Lord. Last order is, Lord, I have handed over the last order.
আমার সিট কত নম্বর আইটেম? হ্যাঁ yes, equal to sleep. Item number 15 let. If it is not taken up, let may I mention that
1 second, 1 second. 15 of
today's list contempt let. Applet side, I'm sorry. There is a direction to pay the undisputed amount that is recorded in the Lordship's order.
Why are you mentioning it out of turn?
It is not taken up.
No, sorry. Yes, call the list, call the list.
Lordship, may I permitted to mention a matter, Lordship, assigned matter?
This bench?
Yes, Lordship.
কি দেখো তো কি?
That mine is also an assigned matter, my lord. Assignment.
কি দেখি দেখি অ্যাসাইনমেন্টটা দেখি আমি। রিলিজ করেছে অ্যাসাইনমেন্টটা কোথায়? দেখে না, যদি অ্যাসাইন হয়ে থাকে দিয়ে দেবে।
Item number 2. 3,
My lord, I appear on behalf of the petitioner.
Four,
My lord, who I am appearing, my lord, for the contemner.
4, 5,
For 3 and 4, man. For the respondent number 3 and 4.
Unless all sides are present today, there's a request from the bar not to take up matters.
6, 7,
I am on behalf of the petitioner.
8,
8, my lord, I am appearing.
9,
8, my lord, I am appearing for the alleged contemner, my lord.
Yes.
Order has been complied with. my
Yes, but where's the petitioner? You say it has been complied with. The petitioner may differ. Pass over. Pass over in the second call. If he comes, we'll take it up.
My lord.
9,
I appear for the appellants, your lordship. The order passed by your lordship's bench has been complied with.
You're for the petitioner?
Yes, your
Oh,
lord.
great. Lovely. Lekho, lekho, lekho. Learned advocate 9. Learned advocate for the petitioner says that the order, comma, violation of which is alleged in this contempt application, comma, has been complied with. Paragraph, in that view of the matter, CP and CPAN such and such stands disposed of.
Your lordship.
number 10, 11, 12, 13,
13, my lord, I appear for the petitioner. I appear for the petitioner.
Not here.
14,
I did ask for the petitioner.
You're for the petitioner.
No, 13 cooling holder.
First decide who is for the petition.
13 voted.
Other side, Mr. Bhattacharya is not there. You have requested us not to take up the matter unless both sides are present.
Unless both sides are present.
14,
Same. I'm for the petitioner.
15,
15 minutes. I have an innocuous prayer, lad. In absence of other side, can be done, lad. Kindly take some, lad. The order dated, lad.
We are not going to record any order today unless all sides are present.
Kindly see the order, lad, if you wishes.
We had directed payment of admitted amount.
No. Direction was that upon me.
Oh.
Direction was upon me.
You are the contemnor?
No. I am the petitioner.
Very well. What was the direction?
Direction was that some of this sum is lying with the office. I am at liberty to accept this amount without prejudicing my rights. That was the direction. And immediately I approached them with a letter. They are yet to release that amount.
So any order we pass will be again adverse to them. Pass over.
In the month of February, the order was passed.
What to do, Mr. Please don't embarrass us. You will make pass a resolution. You will make a request to the court not to take up a matter unless all parties are present. And then if we take it up, then there will be grievance against us.
I'll not insist.
Shouldn't even proceed at all. Thou, bolo.
16,
My lord, I am appealing for the petition. Petitioner.
17, 18,
17, my lord, I am for the applicant, but other side not available. 17, 18, and 19.
All three.
But my lord, only the reply I handed over.
Reply.
Reply.
Give reply.
Reply. In respect of the 17, 18 and 19.
ওটা লিখে নাও তিনটেতেই affidavit in reply. Yes, copy you have served on the other side.
My lord.
Copy of affidavit in reply filed in court today. Be kept with the records. Paragraph. In view of the respondent is not respondents karo. The respondents are not represented. Paragraph. In view of the request made from the bar, comma, let this matter stand adjourned for the day.
Grateful to your lord. 17, 18, 19.
Item 20. 21.
21, Lordship, I am for the petition under direction for personal appearance of the chairman.
That was direction was there.
It took time, that is due to medical problem. Lordship, Lordship took some time, Lordship, the period. So that
We understand, but then,
then
Mr.
15 days
Mukherjee,
is allowed on 1st August 2025.
which municipality is this?
That is Mahestala Municipal.
Moloirai? No. What's the name of the chairman?
No, Mr. Ladin Advocate, Mr. Raghunath Chakraborty is appearing for
Name of the contemptor?
Mr. Dulal Das.
Dulal Das. Today nothing can be done, Mr. Mukherjee. Only not today.
Twenty-two. 22, 23. 24. 25. 23. 27.
No, 25 both sides are there. No, 26. Same. 27.
27, my right friend is here, my lord. I am for the applicant, my lord. Yeah, I'll just remind the lordship. This
I am
matter,
for
your
the
lordship,
returning officer.
under supervision of a lordship.
Who's for the Union of India?
Union of India, my lord, nobody appeared, my lord. Only, my lord, the Register of Cooperative Society appeared. Your lordship appointed the special officers and the returning officer. Election was completed. Only then applicant for extension of the time because 2 directors could not be, my lord, appointed because of certain arbitration proceedings going on. This is for extension. Application for extension.
Now, you are for the petitioners.
Applicant bank, my lord.
Applicant bank.
And appellants, my lord, we have served, but after the matter was disposed of, your lordship once extended, appellants in spite of service did not appear at that time also.
Number 5
The time for completing the process of election.
My lord.
Once it was extended, you want a second time extension. How long?
4 months, my lord. Page 36, that there is an order of your lordship, 10th April, your lordship extended. But
Hey, Ashu. By an order dated April 10, 2024, no, by an order dated October 18, 2023, time for completing the election of the directors of the cooperative bank was extended
from 18th October
by 8 weeks. 18th October by 8 weeks. Stop. Subsequently, paragraph. By an order dated April 10, 2024, the time for completing the process of election was extended by 4 months. Paragraph. The present application has been taken out for further extension of time. Stop. Paragraph. Mr. Naik appears for
Returning officer, Lordship. Returning
Naik,
officer.
comma, learned advocate appears for the returning officer. So if he does not raise any serious objection. Paragraph. The time to complete the election process is extended by 4 months from date. Stop. It is expected that no further extension of time shall be prayed for, and the election process shall be fully completed within the extended time period.
And all concerned parties may kindly be directed to
Stop. All
render assistance.
concerned parties shall render full cooperation to the returning officer, capital, to complete the election process within the aforesaid time period. Paragraph can 6 of such and such stands disposed of.
Grateful, Lordship. Affidavits are with this file.
একবার গোড়ায় নিয়ে নিও। Which one?
24.
Yes, take it, sir.
24টা দেখো, দুজন পক্ষই আছে।
কি করে জানবো কোনটা? হ্যাঁ, আরম্ভ কর না, 24টা আরম্ভ কর না। হোক না।
এইটা 24
হ্যাঁ?
এটা 24 এইটা
Now this is reassemble of those days in code number 6.
হ্যাঁ
সবটা তুললি কে জাস্ট কথা কেনার জন্য?
এত বড় বড় বাবারে
এটা এনেছিস? একটু কপি আছে?
আমি তো বললাম আমার এজেন্টটা বল
কি আর কি মারিস নাকি?
আমি তো বললাম আমার এজেন্ট নেই
নেই তো নেই, অন্য জায়গাতে কষ্ট হলে তুই নিবি। ওই ফাইল করছিস তুই মেমোরেন্ডাম রিভিউটা?
What is this? Review.
Review.
Let us see the order.
Before that, my lord, I have a preliminary point, my lord. Though in 226 limitation not apply in review proceeding, but it has to be within the specific time limit of similar proceeding. Like review is 30 days.
My lord,
Justice Bhaskar Bhattacharjee.
my lord's judgment is there on the kindly see own judgment, division main judgment. I have appeared. Yes.
So he has to plead if it is beyond 30 days. Why this delay?
This my lord's own judgment. It was upheld by the apex court, but not in that sense. But SLP was dismissed. I appeared, my lord.
কপি দে, আনরিপোর্ট জায়গায় দে কপি দে।
রিপোর্টেড হয়ে গেছে, আমি তো আমার কাছেও কপি নেই, দুটো কপি ছিল মিস্টার সাহেবকে দিয়ে। My lord's held on the decision. SFD was filed and it was dismissed. But right now, it against SFD.
কোন পয়েন্টে? সেকেন্ড পয়েন্ট আমি এখনো বলিনি।
Section 5 লাগে না।
আমি তো বলছি লাগে না।
হ্যাঁ, ব্যাস সেটাই প্রিন্সিপাল অফ।
আমি তো বলছি লাগে না।
Section 5 লাগে না। নম্বর क्या है?
But I have not seen the judgment. Probably it's in tune with Justice Bhattacharjee's division bench judgment.
I don't understand. Why have you shown this order? Shaktipada Shah Chaudhary?
Sorry, my lord.
This is very annoying, Mr. Basu. I'm sorry to say.
একটা ঠিক কাজ করতে পেরেছে। In the meantime, to refresh your lordship memory, my lord was
I remember, that's why I told you.
yes, that judgment I brought. Probably my lord is in tune of that.
My lord,
Limitation does not apply. But
my
it
lord,
has to come within the similar type of proceeding,
my lord,
like review 30 days before my lord.
my lord, right now, my lord, I'm sorry, my lord, I am tendering unconditional apology, my lord. On the next date, my lord, kindly fix another date, my lord. I will. No, Dhorala, it is a very good point, my lord. May I submit only one thing?
Cholo, cholo. Anyway, this bench will be the regular bench from Monday. So.
Yes, yes, they did so.
No, it is now not today.
Not today.
আমি কি করব?
Date fix up করার হলে content তুলে দেবো কি?
My lord, only contempt is pending. Showing this, my lord, your lordship knows.
I think, my lord will take hardly 2 minutes time.
এক্ষুনি করে নেন।
Regarding merit, if he wants to.
Can you go to the merits?
Yes, I have no objection. My lord can go. I can.
Very well, my lord has said already, not today then.
Come back.
Obliged.
Monday. কিছু হলো না কি grand acquisition না
Probably my lord will be arranging review part in separate.
We have to. So the first couple of days will be a little
certainly
this way, that way. But we'll organize the list.
So this matter will be on Monday's list.
No.
Or any other day.
এখন হবে না এক সপ্তাহ বলছি
We really don't know.
So this matter will be adjourned till when?
We have just said not today. সোমবারের লিস্টে দিয়ে দাও না তারপরে তো আমরা দেখবো কি করে সাজাতে হয় আমরা দেখবো
Everything in contempt is pending and he is taking advantage.
No, I am not taking advantage. May I just one request, my lord, I am making one request, my lord, that instead of Monday, my lord, can it be fixed on Wednesday?
Monday it will not be heard.
Wednesday আমি আসবো না
Nobody will come.
No, on Wednesday. No, so sorry.
Friday যেন হয় পাঠাটা
ঠিক আছে এখন থাক লিস্টে থাক দেখা
থাক কিছু বলো না
মালদ
6 নম্বর কোডে কেউ আছে বাড়ি 6 নম্বর কোডে কেউ
রাখুন না একবার দুবার তিনবার চারবার ডাকতেই থাকুন
planning to go back to the high court.
Go back to the high court.
Chup.
Yes.
Can you do that?
Yes.
Come to me.
Yes.
My lord, item second call, item 3, 4, 5, 6, 7, 8, 10, 11, 12.
My lord, 12, I am for the petitioner, my lord. I am for the applicant. My lord, if his service is complete.
13.
Oh.
15, my lord, I am on behalf of the contemners. I think, my lord, 20 lakhs have already been paid pursuant to my lord's judgment. 15, my lord, but nobody is there.
16.
Yes, he is for the petitioner.
Oui. বল
15টা দাও
বল Well, may I place, my lord, before my lord, maybe I am the contemner, my lord. Since I have made a statement that I have complied with my lord's judgment, my lord, in a substantial way. My lord, kindly consider my lord's judgment, my lord. The initial judgment, my lord, this landlord.
Take your seat. Take your seat, Mr. Sengupta.
The order dated millet 6 February 2025 millet. And subsequently millet. The order date কত?
The order in question, Mr. Ahmed, is dated 1st April 24.
Yes.
Let us go through it once.
Yes. And
Proceedings under the 2013 Act have been initiated? No.
what they have done, that they have decided a certain amount to purchase the land, and which was not even in terms of the schedule of 2013 Act. Now, last direction passed by your lordship that whether this can be settled mutually and to give us a proposal. That we have made our proposal following the schedule.
This was 6th of February.
That's 6th of February, and thereafter another order. Yes, 6th of February, right. And there was last, I was praying for second page, 6th of February order.
One second. This 10,88,000 that was lying to the credit of your client, you approached for payment of that. What evidence of that is there?
This is the letter, this is a receipt. First page. I'm sorry, I have a single copy.
Not disbursed. And nothing done after that.
But we have submitted our proposal.
As per your calculation, how much it is?
And it is around net due is 65,45,086.
Calculated in accordance with the provisions of the 2013 Act.
This is the last page is the schedule.
And this you have
submitted to them.
Where is the evidence of that?
Receipt. We have a receipt. In fact, by a letter dated 7th March 2025, they have made a communication. Pursuant to that, we have made this proposal.
Yes. Now let us hear them, what they have to say.
My lord, first of all, my lord, my humble submission before my lord, it has been substantially complied. Why? I am saying I put that question to myself. My lord order was previously the Honorable Single Judge passed an order directing the authorities to make payment in terms of pass an award in terms of the 1894 Act 1. However, my lord, after that, my lord's appeal was preferred, and my lord passed an order in the sense that the appeal, you have to draw a proceeding under the you have to initiate a proceeding under the provisions of the 2013 Act and pass an award. My lord, compensation to be made in terms of the 2013 Act. My lord, I am reading, my lord.
Don't read. We have read it.
Yes. So, my lord, at that juncture, my lord, kindly consider one thing. My lord is right, absolutely right. But, my lord,
what have we said that we are right? We have said nothing.
No, because
where are we right?
The division bench order regarding the compensation part but not initiated to be done or made in terms of the provisions of 2013 Act, that is not applicable. However, I didn't file any review application, I should be honest to my lord. But there is a judgment, recent judgment of the Honorable Appeals Court, which says, even my lord.
We have passed a wrong judgment.
No, my lord,
it's still binding on you,
it's
unless set aside.
Compensation part, compensation only to be in terms of the 2013 Act, that is section 26 of the 2013 Act. And we have followed that 2016 of the 2013 Act regarding granting of compensation. And my lord, we have come to a finding that 17 lakhs and odd have been paid. And my lord, the total amount, my lord, kindly see, even 11 lakhs something has to be paid. Another. So that is up to 28 lakhs something, according to our estimate. In terms of the provisions incorporated in 2016, provision 26 of the 2013 Act, what they are seeking a further thing regarding compensation, that is Schedule 1, I have complied with. Schedule 2, Schedule 3, which Schedule 2 and Schedule 3, well, this is after all in a contempt jurisdiction. But we say Schedule 2 and Schedule 3 is not applicable because of the provisions inbuilt in the statute. They are seeking an additional compensation on the basis of Schedule 2 and Schedule 3, which my humble submission before my lord, that is not applicable according to the provisions as incorporated in the statute. 2013 Act.
As per your calculation.
As per your 28, sorry.
11 lakhs
Still due. Yes, my lord, we have told that to get that, but they refused.
ওর তো নিজের estimation অনুযায়ী এখনো 11 লক্ষ টাকা তাই
Ask your client to prepare to go to jail then, because our order is quite clear, 6th February order,
yes,
that the computation that the petitioner will make is in terms of the provisions of the 2013 Act, including the schedules there too. Simple English,
yes,
nothing complex. Now, if your client was agreed by this, should have challenged this order before a higher forum?
No, I didn't.
Or we are saying should have. Has not done that?
No.
We'll be granting you 7 days time to comply with this. Otherwise, very severe consequences will follow.
Well, may I submit only one reference, my lord, as Supreme Court judgment. Well, on the basis of in the contempt jurisdiction. Well,
yes, in the contempt jurisdiction, what is the proposition?
A proposition of law that even if certain order was passed by the Honorable Division Bench or the Honorable Single Judge, that you should, directing the authority, you should pass in that way. Authority did not pass in that way. Authority rejected that order, the petition.
Rejected that order?
Rejected that order. That order means authority rejected their seniority list. They filed a contempt application. In the contempt application, Supreme Court held, 3-man judgment, that even if there is an error and they did not act in terms of the court's order, that is a separate cause of action. For that, my lord is already aware of that.
Yes, we are. We are aware of it. Yes. It has no manner of application in this case. Because here, there is no error. There is non-compliance. There is a clear difference between the two. You are trying to sit in appeal over our order, saying that the 2nd and 3rd schedules will not apply. Now, that is audacious enough of your client, and he will face the music.
My lord, may I beg one submission?
He'll face the music.
My lord, may I beg one submission? Kindly give us at least 14 days time.
2 weeks time, very well.
2 weeks time, my
2
lord.
weeks time.
2 weeks, I think 2
Yes. No, your thinking is immaterial. We are not going to grant you more
My
than
lord,
2
only
weeks.
the 10 lakhs and or odd is also according to our estimate, my lord.
Pay it. Why are you withholding it? Without prejudice, they'll accept it.
11 lakhs and that are
Bring the pay order to court.
I'll go
yes,
to the office tomorrow.
my lord, I will,
Tomorrow. They'll go tomorrow.
yes, they'll go tomorrow.
Without prejudice, they'll accept it.
Yes.
দেখো তো।
শনিবার অফিস খোলা থাকে? হ্যাঁ? শনিবার তো অফিস খোলা থাকে না?
Tomorrow is Saturday.
Tomorrow Saturday.
Monday will it?
Monday.
My lord, at least 21 days time. 21 days.
Read order dated February 6, 2025, paragraph. By that order, we had granted liberty to the petitioner to send a computation of the compensation that he is entitled to in terms of the provisions of the 2013 Act, including the schedules thereto. Paragraph. The petitioner says that he duly sent such computation, which was received by Special Land Acquisition Officer. Special Land Acquisition Officer. Stop. The amount comes to approximately rupees 65 lakh. Paragraph. By the aforesaid order, we had also granted liberty to the petitioner to accept the sum of rupees 10,88,108, which, we were told by learned counsel for the contemnors, is lying with the land acquisition collector, North 24 Parganas, to the credit of the petitioner. Stop. Paragraph. The petitioner says that he approached the land acquisition collector, North 24 Parganas, to collect the aforesaid sum of rupees 10,88,108, without prejudice to his rights and contentions in the pending legal proceedings. Stop. However, such money was not made over to him. Stop. Paragraph. Learned advocate for the contemnors says that there must have been a communication gap. Stop. If the petitioner goes to the office of the land acquisition collector, North 24 Parganas, on Monday, November 3, 2025, around midday, the said sum of money will be made over to the petitioner in the form of bank draft.
Well, I think not in the form of because now in the bank draft is required.
Electronic transfer.
Electronic transfer, yes.
As well as business.
By কি বললাম, in the form of কেটে দাও, made over to the petitioner through NEFT. NEFT block capitals. Stop. The petitioner shall furnish the requisite particulars of his bank account to the land acquisition collector. Stop. Let the aforesaid be done. Stop. We trust and hope that on Monday, November 3, 2025, the petitioner shall receive the aforesaid amount of rupees 10,88,108 from the land acquisition collector, North 24 Parganas, without prejudice to his rights and contentions in the pending legal proceedings. Stop. Paragraph. Learned advocate for the state further says that as per the state's calculation, a sum of approximately rupees 28 lakh.
20 lakhs and odd, right now I can.
Approximately means what?
Yes.
Rupees 28 lakh is payable as is payable to the petitioner as compensation. Stop. While arriving at such figure, the state has taken into account the first schedule to the 2013 Act. Stop. However, the second and third schedules are inapplicable to the petitioner. Stop. Therefore, the petitioner's computation is based on computation takes into account all the three schedules to the 2013 Act, and therefore the figure arrived at by the petitioner is much higher. Stop. Paragraph. Our order dated February 6, 2025 is quite clear. Stop. It permitted the petitioner to compute the compensation amount payable to him by taking into account the provisions of the 2013 Act and the schedules there too. Schedules within inverted comma though. Stop. That order was not challenged by the state before any higher forum. Stop. The state or the alleged contemnors cannot be permitted to argue that the petitioner's computation is erroneous, since it takes into account the second and third schedules to the 2013 Act also. Paragraph. Learned advocate for the state seeks a little time to obtain further instructions. Stop. List this matter.
At least 21 days.
2 weeks. No. You said no. Mr. Shengupta, there's a limit to everything.
Yes. My lord, only one thing, my lord. Yes.
Let us complete this sentence. 17 karo. November 17. শোনো এই বেঞ্চি তো কন্টেন্ট গুলো আবার শুক্রবার তাহলে দিয়ে দেবে ওই 17ই। Yes, what else?
My lord, if I may be permitted to make one humble submission, if my lord allows me, my lord, my submission would be, my lord, don't make me amiss, my lord. After all, I am facing the contempt, my lord. The order which my lord has passed, my lord, that all schedules are taken into consideration. That is not the original order in the my lord's, that is under contempt, my lord. Kindly record.
You're just aggravating your client's case.
My lord, I'm sorry.
I'm extremely sorry. I ought not have been insisted in his absence.
Yes.
Sorry, sir. Kindly excuse me.
Oh, 14, sorry. 14 November.
14.
14 November. Don't scratch your head. Children's Day. Children's Day. We all have a child within us.
My lord, I am requesting, my lord, only at least 21.
Hey, 21st November. Take your 10 lakhs first.
That means 10 lakh.
21st November.
21st. Oblige. Well, me, I leave.
My lord, I am appealing for the applicant, my lord.
My lord, I am for the alleged contemner. My lord, I am told, my lord, that we have taken out a review application of my lord's order. My lord, let that review, my lord, be.
That is not listed. Let it be listed.
But my junior would give the all details.
Have you served the contempt on them?
Yes, we have got.
Past occasion, my lord, there was a direction.
We sought for time to file a counter. Instead of that, we have gone through the papers and we have found there are substantial issues which my lords, subject to my lord's wisdom, may review the order. We have taken out a review. My junior will give the numbers and all details.
Referred, my lord, and that has been dismissed.
Yes. SLP dismissal doesn't prevent them from
law is well set.
Filing review.
Unless leave is granted, my lord, that review is always meant.
What distillery?
Lordship, my lord.
Khodai Distillery. The Supreme Court decision.
Yes. Two division men, then conflicting, my lord. Third. I even argued, my lord, at
give
one.
The number.
Yes, my junior.
16 at order record karo.
My lord, the copy has not been served.
Unless
thou has to dictate. Learned advocate for the alleged contemnor says that the alleged contemnor has filed an application for review of the order comma, violation of which is alleged in the contempt application. Stop. Let that review application being
RVW 301 of 2025
be listed along with this contempt application a fortnight hence. Paragraph, in the meantime, let service of the review application be effected on the petitioner in the contempt application.
Much obliged.
Item 21, 22, 23, 25, 26.
না থাকলে নট টুডে করে দাও। ও কল করেনি?
What does say? New application, item number 1.
জুড়েছি।
Item number 2.
ফেরত থেকে 27। রিভিউ তো আমাদের কাছে থাকবে না, ওটা বসাকে কন্টেম্পট থাকবে না, ওটা থাকবে। কটা থেকে কত নম্বর হলো? 35 থেকে তোমার শুরু শেষ হচ্ছে 192 না 192 ঠিক। তারপরে আবার বলছি কম্বাইন। সাইনটাও করতে হবে, তারপরে হিয়ারিং।
না তুমি ইলেকশন পাচ্ছে না, এগুলো দেখি যে ইলেকশন হয়ে ওরা পড়ে রয়েছে 15 বছর দেখা যাবে যে আলটিমেটলি কি হবে তারা একই
Lordship, I'm appearing for item number 27.
We are in regional side, sir. হ্যাঁ, এক নম্বরটা কেউ ছিল না? Yes, number 2.
Application for restoration of the applicant. Down, my lord, the petitioner advocate on record became ill
Have you served on the other side?
at the time of it was not admitted. New motion, new appeal dismissed for this.
কবে কি দেখি দাও।
My ground, but
Why, where were you? On that day, where were you?
ill, my lord, I released the medical certificate.
You were ill.
Yes, I could not attend the court. Well, kindly see my medical certificate annexed at R1 page 8.
This is an application for restoration of APOT 92 of 2024, comma, which was dismissed for default on April 8, 2024. Stop. At that stage, comma, the appeal had not yet been admitted and service had not yet been effected on the respondents. Stop. Hence, we take up this matter ex parte. Paragraph. Having heard learned counsel for the applicant, oblique appellant, we are satisfied with the explanation furnished for absence of learned advocate for the appellant on the day the appeal was dismissed for default. Paragraph. Accordingly, the order dated April 8, 2024, is recalled. Stop. APOT 92 of 2024 is restored to its original file and number. Paragraph. GA such and such, GA 1 of such and such is disposed of. Paragraph. List the appeal 1 week hence. Before the appropriate. Before the appropriate bench.
Application, I can know 3 and 4.
My learned friend had completed his arguments finally, my lord. My lord, two main points were taken here. One was that, my lord, the building is more than 21 meters in height. Therefore, under the schedule to the 1951 Act, KMC, Calcutta Municipal Corporation Act at that point of time, more than 50% vacant area ought to have been left. And if 50% vacant area ought to have been left, then that 700 square meter forms part of the 50% vacant area. This was the primary submission. And the second point, which was urged, that there's an affidavit by one of the directors of the my company, who had in 2003 said that this 700 square meter is earmarked as parking, and therefore that has not been considered by your lordship.
Apparently, KMC also said so.
Your lordship has already dealt with that in your lordship's order, the KMC's part. So these are the two main points which were urged. My lord, if your lordship, this first point of the building being of more than 21 meters and Rule 20, Sub-Rule 2 of 1951 rules being applicable, 50% vacant area has to be left behind. Well, at this point had been urged by them previously, and it has already been decided. Well, previously, this association had filed a civil suit. In that suit, they had claimed right over this 700 square meter. From that, the matter came, from interlocutory orders passed, the matter came in civil revision. In civil revision, this identical point was taken, and the court has held that as per their own sanction plan, which they are relying on. Your lordship will remember there were two sanction plans which were being relied upon. One by us, a certified copy, and which has been also held, which is the same as the copy which has been supplied by the KMC, and a second copy which they have relied upon. Now, so far as the copy which they are relying upon, on that copy itself, it shows that the building is actually less than 18 meters, and therefore not Rule 20 Sub-Rule 2, but Rule 20 Sub-Rule 1, which will be applicable, which says, my lord, that if the height of the building is less than 18 meters, then in that case, my lord, 2/3 is the open area, only 1/3 open area is to be left. Vacant, 1/3 mandatory open space is to be left. My lord, if your lordship takes, my lord, the judgment of Justice Shobhoshachi Bhattacharya in civil revision first, and then I will show the facts also, my lord. Back on. My lord, the civil revision. Well, this is part of the documents also, but I'm just relying on it separately. Well, we'll first take paragraph 10. Once, paragraph 10 of this judgment. The judgment of 27th November 2019. Paragraph 10. Well, this is the submission of the association. In this context, the petitioner relies upon the provisions of Rules 20 Sub-Rule 2 of Schedule 16 of Calcutta Municipal Act 1951 in respect of 50% covered area in relation to construction of the buildings, and Rule 22 pertaining to restrictions. On this point, the finding is at paragraph 63. 60 paragraph of finding type. 61. Well, at page 55. There is no clear mention in the purchase deeds of the members of the plaintiff petitioner as regards their having any parking space specifically over the suit property. Rather, in the plaint of the first suit, it is categorically mentioned in para 5 to 7 of such plaint at page 462 of the revisional application that 700 square meter area was excluded from the purchase, the plaintiff's member and one from the purchase of the plaintiff's members, and the 1/3 of the total area was kept vacant. Now, next, however, a contrary claim of 50% vacant area has been made in the present suit, which belies the contention of the petitioner. Even the purported sanction plan of the petitioner shows that the construction of less than 18 meters, invoking Rule 20, Sub-Rule 1 of 1951 Act, which provides for 1/3 vacant space to be left and not 50% as pleaded by the petitioner in the present suit. Same point was urged. And now, how I'm showing it, if your lordship takes their plan, I've taken the legend in their plan, my lord, I've taken a photocopy of that separately because that provides this in detail. And I have the full copy of the plan also. My lord, if your lordship sees, this is just the legend which forms part of their plan. My lord, if your lordship sees, right at the beginning, statement of areas, area of plot is given, open space 1/3, permissible covered area 2/3. In their plan itself, this was mentioned. What they did, Malad, it is our contention, this is a fabricated and forged plan. What had actually happened, Malad, I'll show from our plan also. Each floor is 2.95 meters. The building constructed is ground plus 5. And in fact, also, if your lordship goes and sees, it's a ground plus 5-storied building. So 2.95 into 6, ground plus 5.
5 into 350.
Less than 18, 17.70. So it's less than 18 meters. What they have done, my lord, in this, although the first part, they have calculated it rightly. Open space 1/3, permissible covered area 2/3. Subsequently, they've said, my lordship will see it goes to ground plus 7 floors. So therefore, they have said it is more than 21, more than 18 meters. In real, the plan was actually for ground plus 5. It has actually been constructed as ground plus 5, and the total area is less than 18 meters. And therefore, the first part of the plan of this map is correct, the legend, which says, my lord, open space is 1/3, permissible covered area is 2/3. Had it been more than 18 meters, it would have been open space half, permissible covered area half, as per the rules. Now, the rule also, if your lordship just checks one, my lord, the rule has been set out in their appeal. In the stay petition can 1, if your lordship, I don't have a copy of the rules, but the rule has been set out, my lord.
That handed up
Separately, then the rule is, I don't have a copy, but if your lordship takes the rules, my lord, also. 1950. Leading a cheta. Your lordship, this is Schedule 16 to the Calcutta Municipal Act 1951. Their cases that the construction comes under Rule 20, Sub-Rule 2, whereas this comes under Sub-Rule 1. And that's the finding of Justice Bhattacharya also. If your lordship just sees, Rule 20, for all buildings not exceeding 18 meters in height, the total area covered by the buildings on any site shall not exceed 2/3 of the total area, leaving 1/3 open space. And 2, for all buildings more than 18 meters in height, the total area covered by the buildings on any site shall not exceed 50% of the total area. So, my lord, that contention is belied by their own sanction plan, or by the copy of the sanction plan which they are relying upon, number 1. And number 2, my lord, there's a finding on this already. Yes. Finding on this already. Well, just for the purpose of showing what the height of each flat is also, each floor is also, my lord, this is the certified copy of the floor plan on the basis of which construction has happened. I will just show it. take copy of it. My lord, if your lordship just takes this copy, এইভাবে সোজা আছে, এইভাবে দেবেন। My lord, your lordship will see each floor plan is there, and on the right side of each floor, my lord, if your lordship sees the extreme right of each floor, at the border, my lord, in fact, your lordship will find there is 2.95 meters.
The right hand side, my lord.
Right hand.
Right.
না না ও তো দেখাচ্ছে বাঁদিকে।
It should be somewhere right here. At this.
2.95.
2.95 meters. On that basis, my lord, it has been calculated to be less than 18 meters, and therefore 1/3 open space. Your lordship, you can keep one if you want. No problem. So, the floor plan. তোমাদের এই floor plan হইতে কোন? নিয়ে নাও। আরেকটা কপি মার্ক করা দিয়ে দিচ্ছে।
Very well. We have to rise at 3:30.
Well, should we come back next week?
Yes, you have to come back, not next week, week after that.
Week after that.
Contempt রাখবে Friday week.
We should not take much time, my lord. The second point is also actually covered, my lord.
Mr. Shorbupriyo Mukherjee, learned counsel, appearing for the respondents in the review application, begins his submission but does not conclude. Paragraph lists this matter. এটা কি দুটো matter একসঙ্গে হচ্ছে? List these matters once again on 14th November 14, 2027. 2027.
Instead of 14, can it be 21st? Friday thereafter, 14th.
Yes, 21st. 21st. As requested by Mr. Dashgupta, learned advocate for the review applicant.
I was led by Mr. Mitra in the matter. He's not yet reached. He's still on his way.
If you can see him give his name, we'll say nothing. চলো এই কোথায় গেল?
দিয়ে দেবো আর রিডিং যেটা আছে সেটাই তো থাকবে, অন্য কি করে করবো?
Mr. Mitra, want to say something? All right.
Obliged.